The visit by Chris Marsden to the University of New South Wales was made possible by the UNSW AI Institute.
So good afternoon and welcome everybody to this presentation by Professor Chris Marsden. Chris has come up specifically from Monash Law to discuss European AI law and regulation. And Chris is the newly appointed Professor of AI Technology and the Law at Monash University. For disclosure, Chris and I have embarrassingly known each other for nearly a quarter
of a century,
and I'm sure that you'll all enjoy the presentation that he's got this afternoon. So thanks, Chris.
Thank you, Rob, and thank you to the people who are online and in the room. People in the room are shivering like me with the unseasonal temperature. As Rob said, we've known each other since the last millennium, and we've been talking through a whole range of technology law problems, from satellite broadcasting to telecommunications and access to the network, when the NBN was a new and exciting idea that we thought might be a real leap forwards. And then leading on to, well, a lot of my work was around the topic of network neutrality, which is actually in a way becoming a bigger issue in Australia now than it was when it was a big noise in Europe. And then on to looking at AI. And my specific research is into the uses of AI to disseminate and to combat disinformation, which is another one of these really large-scale transdisciplinary problems that emerges. So I'm going to talk about EU AI law and regulation for about half an hour or so, giving a European perspective and then bringing it back to really in the Q&A to talk about what this might mean for the Australian experience. I appreciate that with the new government, which is now suddenly very, very interested in data protection law, as a result of the Optus, I'm not even going to call this a leak, the Optus open server and other problems that have emerged around that, that this is obviously becoming a big focus. Remind me to make sure that my conclusion is really clear, which is that the European AI Act is actually a presumptive deregulation of AI. And I'll explain why that is. Punchline is essentially, if Europe wasn't to regulate AI across the European Union, the individual member states would be free to regulate in this area. By introducing a common European legal standard, we ensure that individual European countries, and that almost always means Germany, is not able to tighten regulation of AI beyond this common standard in Europe. So when you see, oh, there's a new European law, a lot of, particularly the business press, will say, oh, that's going to make regulation much, much stronger. That is almost never what's done by European law. European law establishes a common standard, which is not just a baseline, but of course it's also, to a large extent, a ceiling for regulation. And that's what's being done. And weirdly enough, or perhaps not weirdly enough, that is exactly what's happened previously in all of the other things that Rob and I have talked about over the last quarter of a century. So let me go on and talk about this a little bit. And this was a conversation I had. I was delighted to spend some time with Toby Walsh at the Data Futures Institute from Monash. I had something called the AI Summit in Prato a couple of weeks ago. That's me recognizing that the camera adds at least £10 to you. I will argue a lot more, talking a little bit about this. It's important to mention, Monash, amongst other things, has the Prato Foundation, which means that Monash is now essentially a European university, as well as an Australian, Malaysian, Indonesian university. So these conversations are very much ongoing from inside as well as outside. Obligatory, I'm sure UNSW has its immersive 3D wall as well. This is the Monash version. We're going to have a conversation with the metaverse people in a couple of days' time, so I will probably keep this slide in. So, problem simply is AI in the wild has raised complex public policy and ethical questions. This is not surprising to us. Perhaps what's surprising is the extent to which it's suddenly become almost an obsession in public policy in lots of parts of the world. When we actually talk about AI as opposed to simply algorithmic regulation, which is the thing that I think most of us are much more comfortable with, because it doesn't beg the question of how do we define AI, we see public deployments in social media, We see it in insurance very, very clearly, and I know there are people in the room who have written about this. In cybersecurity, of course, and we have specialists in that areas. And of course, in areas which are really fun because it's all of the above really mixed together in lots of different ways. And I always put up the spam slide because we know that there were deployments actually looking at this from early 90s, arguably even earlier than that, dealing with some of these issues. Okay, so from the European experience, before we had the AI Act, which I'll end up talking about, we had the Digital Services Act and the Digital Markets Act, which are actually two separate pieces of legislation, which they claim are aiming to create a digital safer space. This is their argument. I'm going to talk a little bit about both pieces of legislation, only in as much as they infringe on AI and impinge on AI and help us to talk about AI. I hoped, and this slide was written in the hope that they'd actually published the laws, and of course they haven't. So in the next couple of weeks, they will actually officially become European law once they're published in the official journal, which will happen very soon. And I'm going to think a little bit about how this might affect what we're going to do in Australia. But I think really, obviously, I'm going to look for some insights from you guys. And also, I think all of us will have to speculate because it does seem as if the government has 25 pieces of legislation that we would like them to pass in connection with technology. And maybe we will see something said about AI within laws which are not ostensibly dealing with AI at all. Okay, let me give you a chronology of legislation because frankly, I find this confusing, so I'm sure everybody else does as well. The Digital Markets Act was proposed in 2020, and I'll explain what it does in a second, or very, very briefly. Regulatory agency enforcement of that is likely to take place maybe in 2023, maybe more likely, to be honest, 2024, because of course it's not yet quite legislation, will be in a couple of weeks. Digital Services Act, which goes alongside it, again, proposal at the same time, a little bit more delayed in terms of its publications legislation, enforcement probably 2025, in as much as there will be very much of that. The AI Act, which is not actually the AI Act, I'll explain what it's actually called, proposed same year, going to be delayed until at least 2026 in terms of regulatory enforcement. And then there is a very new AI Product Liability Act, which has just been proposed and which will be at least 2027. This slide will, of course, be destroyed in case people try and use it in evidence against me in a couple of years' time. But I thought it would be helpful to talk about not what they say, but what the likelihood is in terms of the teeth of this thing. So full titles for reference of the DSA and the DMA. Digital Services Act is the top one. Digital Markets Act is the bottom one. People will never use these titles, but they will be in footnotes in forthcoming articles. So let's just be aware, this is what we need to do when it comes down to it. But again, of course, ruining it, these are actually just, at the moment, the Council of the European Union's titles for the working documents, because we don't yet have the final publication. Which relies upon it being translated into all of the working languages of the European Union, which do include English, just for those of you as a footnote, because it's one of the official languages of Ireland, although Irish is now recognised as an official language of the European Union, but English is a language of the European Union, despite the Brits doing whatever the Brits think they're doing. Okay, and here is the actual signature of the DMA, being signed by Roberta Metsola, she's the President of the European Parliament, President of the European Council, and it's overlooked by the sponsoring members of the European Parliament, most importantly being Andreas Schwab, MEP, who's probably the most well-known of the parliamentarians dealing with these various laws. Okay, so Digital Services Act, as I say, 15 months after publication of the OJ is when it will go into effect. That's the broad one. So the one that will affect all online parties who have a commercial interest of any type will be the Digital Services Act. So it applies to virtually all online services, including smaller services as well. It actually tidies up some of the very poor wording of the existing law, which is the e-commerce directive of 2000. There has not been a compendium law since then. It will also apply to, and please get used to this ugly term, which we're going to have to use all the time, very large online platforms are VLOPs. And the VLOP is actually the main regulatory actor who is affected by the big fining mechanisms in this. And I said to Rob earlier on, I must mention, because people get terribly excited by these, people will remember the GDPR has a potential maximum fine of 4% of global annual turnover. For the DSA, it's 6%. For the DMA, it's 10%. And as currently drafted, it's 6% in the AI Act as well. Those are maximums. Do not assume that we're going to see anything like these, but those are the maximums which are possible. And of course, they're terribly exciting, because when it comes to the VLOPs, which is the likes of Google and Meta and Apple, that's of course adds up to a pretty sizable number in the end. Okay, by the way, a VLOP is what the European Commission says it is. And so the European Commission has a unit currently looking into the articulation of that. There are guidelines for it in the Digital Markets Act. I will maybe just puncture one point of potential misunderstanding. Twitter is not and is very unlikely to ever be a VLOP. And that's because it doesn't have a large enough European user base to actually be a very large online platform. But others are, obviously Meta and Google and Apple and others. Okay. This seems to have received a great deal of traction recently. The claim that's made by Luke in this article, and it's a claim that perhaps all of us have some recognition of, is that we've spent a huge amount of time talking about ethics and AI engineering over the last decade. His claim is not that AI ethics is actually useless, it's a provocative title. It's that we do need to codify some of these ethical choices that we're making in legislation sometime very soon in order to achieve what we want. I should say a lot of the United States literature dealing with AI ethics is born out of a certain frustration of the fact that they know that the US Congress is very unlikely to pass at a federal level a really useful piece of AI and ethics codified in law. You're probably all aware that the White House very recently, 5 days ago, published its AI Bill of Rights, which is not an AI Bill of Rights, but is nevertheless the White House saying this is what we would do if we had control of Congress and were able to actually pass useful legislation. But I think one of the things that's really interesting about the way that one can study the European law in this space is that it may be, and for those who came in late, the punchline is it's designed as a minimal piece of legislation to stop a country like Germany passing a more effective, sharper-toothed piece of legislation. The European approach, nevertheless, does have a legislative foundation that will be enforceable in as much as it is. Word of warning at the moment, anybody who tries to tell you this is what the European AI Act says has to give you 3 health warnings. One is it doesn't really know what it defines as AI yet, and it's likely to change very rapidly. Secondly, it's draft and is going through a very substantial period of amendment. The third is, of course, they called it an AI Act. First of all, the European Union doesn't have acts. It's not a common law jurisdiction where an act is anything meaningful. What they mean is a regulation. So it's a regulation of the European Union. And the second part of that is that, of course, if we are going to confuse ourselves with the common law terminology, so it's a bill, right? It's a draft piece of legislation. There are 3,003 meaningful amendments that are being debated this autumn by the various committees of the European Parliament. I will not take you through their flowchart. People who are really interested in this, and it's actually quite a nice piece of a figure trying to show you what goes on. There is something called the legislative train that you can study. So if you go AI Act legislative train in whichever search engine you may use, I don't want to be prescriptive, then you will discover the description of how this goes through committees. Good luck with it, and please feel free to email me afterwards and say, it says it goes through these committees, but there are these acronyms that don't make any sense to me, and I will explain to you that they don't make any sense to me either, probably. Nevertheless, so it is a horizontal transnational law. It applies across all sectors, so it's not just about medical devices or specific elements of, for instance, insurance or credit risk or any of those individual things. It goes across the board. It is deliberately designed to prevent more effective national laws. The reason the European Union has moved on this now, in 2020 to 2023, as it will be when it's finally enacted, is to stop any individual country offering something much more substantial, particularly Germany, because obviously this is far and away the largest single economic actor in the European Union. And this is the story of the e-commerce directive of 2000, for those with long memories. That was also what was done back in 2000 to stop an individual country, specifically Germany, from introducing much tighter regulation in that area, which was then, of course, online services as they emerged. It may well say something about live facial recognition. That is a huge battle in the European Parliament this autumn, and I will not predict who's going to win the outcome, and also other high-risk AI deployments, which I'll talk about. Okay. Very basic problem. We know that whatever's happening in this, as in many other technological fields, has a pacing problem. We will be debating things in the AI Act, which will not, unfortunately, look very effective in 5 or 10 years' time. That's why we have judges, that's why we have regulatory agencies, that's why we have legislation which is meant to be future-proof and flexible. But we know we have this issue. I like to give this illustration of the issue these days. I think it's important in our research that we acknowledge that we've lived through a pandemic. This is why some people are online. These are attempted cures for the Russian flu of 1889. And one of my least favorite cases of all time, the carbolic smoke ball case, which dates to that period, which was that you essentially were supposed to inhale smoke, and this would protect you from the effects of the Russian flu. It wasn't terribly effective. That's what that case is about. But anyway, there wasn't a specific law that outlawed the carbolic smoke ball at the time or anything else like that. So what I'm going to describe when we look at the AI Act, and Rob and I have talked about this many times before, is the Railways Act of 2023. It is an attempt to deal with a relatively immature technology in an attempt to actually lay down some baselines to stop the very obvious abuses that might take place with it. And I always harken back to the Railway Regulation Act of 1844, which was the classic attempt at the beginning of the modern, well, towards the beginning of the modern industrial era, to deal with networked technologies and their regulation of the time. I normally actually harken back to this legislation in an attempt to suggest to the legislators that they're heroic, kind of Gladstone figures of their time, because this was William Gladstone's first piece of work as a legislator. Of course, he had earlier work where he was compensating his own father for being the largest slave owner in the British Empire, which is a part of Gladstone's career that we sometimes overlook. This is him as a legislator. This is him as a minister. This is the heroic Gladstone, as opposed to some of the other stuff he did. Oh, and yes, there's so many things to say about Gladstone. So, single side on the AI Act. Designed to avoid regulating AI by preempting, sorry, that sounds terrible, but it is designed to prevent too much regulation of AI by preempting nations that might actually try. Because this is a European piece of legislation, it does mean, of course, enforcement is placed in the member states, and that typically means in Dublin or Luxembourg, because we are talking about, when we're talking about the VLOC companies, we are talking about their European base, which is for the most part Dublin, but also including Luxembourg. I don't know if you have any taxation or finance lawyers in the House, but they will know about the regulation of those countries for those purposes. A weak European law will prevent stronger national laws, and that is exactly what happened, for those with long memories, with the net neutrality regulation of 2015, what was called the Open Internet Regulation 2015, which actually, as a result of that piece of legislation, the regulation dealing with that issue, both Slovenia and Netherlands, which already had stronger laws in place, had to repeal those parts of their stronger net neutrality laws because they were incompatible with the European law. And that took 6 years to confirm through the European Court of Justice because of their particular issue, which is zero rating, which I can talk about later. Okay, so when we think about the draft law, we are comparing it, of course, with other, I'm going to call these advanced democracies. Those of you familiar with the United States may quibble at that term, but nevertheless. Other places and where we are, and will we see what's often been called the Brussels effect, right? The percolation of the European legal standard into other parts of the world. With a warning, the Brussels effect, of course, is almost always the Dublin or Luxembourg effect, and it's possible that other parts of the world don't quite fully appreciate we're talking about a Dublin or Luxembourg effect as opposed to simply a Brussels effect. So I'll talk about that. I always finish off talking about co-regulation. Those who have seen my talks before know that I always end up talking about co-regulation. One of the reasons why I'm so happy to be now established in Oz is to look at the way that we might look at things more effectively there. The UK has obviously taken a very, very sharp turn towards self-regulation over the last 6 years or so. Okay. Actually, no, I'll skip on the Robo-Debt Royal Commission. We'll come back to that because that will be an issue that we have to deal with later on. So when we talk about the evidence that was being raised about the AI Act, we're very much thinking about evidence which is becoming relevant to politicians, but which politicians aren't fully understanding. And so people have talked about what's happening with AI as being basically policy-based evidence making. Politicians very much picking and choosing the bits of evidence they want to use. And Toby Walsh was very, very helpful in Prato, talking about some of the ethics washing issues that have arisen in connection with some deployments of AI, how we might deal with those using things like human rights impact assessment. A lot of discussion that I've seen very recently about AI is about the fact that AI systems are very much designed for efficiency, which when you think about it, I'm going to make this argument, is a utilitarian standard. It's sort of a 200-year-old kind of Benthamite law and economics idea that we're trying to achieve a utility outcome. And that seems a little odd to some of us who are very much used to dealing with human rights-based analyses of some of the deployments of AI. And so part of that argument is, because of course yesterday we lost Bruno Latour, great philosopher of science and technology studies. I won't go through this in detail, but a lot of what was written in 1979 by Latour and Bulgar is still extremely relevant to a lot of the AI analysis that we undertake today, is that we have to recognize that when we are deploying AI, we're deploying it according to our own prejudices, our own values, our own views of what ethics might be. And it does result in some very divergent outcomes. The AI Act might actually stop some hype around AI. We're all conscious of sort of hype. And one of the things that it will do, of course, is say that if you are running an AI system, you will be subject to regulation. That might make some companies decide that they're not actually running an AI system at all, but they're running statistics with a bit of machine learning. And they might be able to say, oh, yes, we're not anymore actually going to claim that we're running lots of AI because we've decided we don't want to be within the legislation. And I won't go through in great detail about the hype, but I hope everyone has their own AI hype slide of preference, and this is mine. The one thing I will say that's really interesting, at least, or alarming, and again, I'm not claiming that there's great provenance for these figures, but when it comes to talking about private investment in AI, there is effectively one country in the race and everybody else following it. Now, I've plucked these figures from my own favorite consultancy. You can pluck your own figures from similar consultancies. The numbers may not be entirely accurate, but I think the scale is. And when you look at individual countries, Australia or South Korea or France or even Germany, you see the numbers are so dwarfed by one and potentially a second market. Okay, so this is the reality that we're dealing with. And on the right is my favorite standards making body, which becomes really important in the story about how Europe is dealing with AI, because when the question will be asked at the end, so I might as well tackle it now. What is an AI system? What is the legal definition under the European AI Act? The answer is refer to Annex 1 of the draft regulation, which says it is essentially what the European Commission decides based on the advice they're given by something called the Joint Technical Committee, which is a joint ISO-IEC technical committee. And that's the legal answer. The legal answer is refer to what the technical committee says it is, which is, well, we'll have a Q&A discussion about how legitimate that might be. Here is this slide which actually tells you the graphical demonstration of what it is that the European AI Act says that it's doing. It says there is a red zone at the top, which is unacceptable risk. These are AI deployments which cannot be permitted in the private sector, I should add, under the AI Act. And there are some thoughts about what they may be, but I've included facial recognition there on this particular stolen graphic from the internet. And I think there is a debate as to whether facial recognition, and by which of course we're talking about live facial recognition, in other words, moving image facial recognition. We're not talking about, as my student said to me, does that mean I can't stare at my phone to open it anymore? I said, no, that's okay. That use is acceptable for lots of reasons, including consent. But there will be some elements, and people have often talked about social scoring, by which they loosely mean what they see as a dystopian version of what's happening in China. Again, not very well identified, at least legally defined. They talk about dark pattern AI, which again, there's a whole discussion we can have in this autumn. The Parliament will be having that discussion this European autumn, this Australian spring. But then there will be high risk, limited risk, and minimal risk areas. Minimal risk means you don't need to worry about the AI Act because you'll be able to decide that you are entirely within scope, and the AI you're deploying is not something which regulators are going to be concerned about. Limited and high risk, you'll have to take increasing levels of audit of your processes to make sure that you're ensuring that you come within them. Again, very controversial. We'll probably come back to this in Q&A, so I'll skip over it for a second because we will come back to this. Oh, and this is how it's done in reality. This is the process that the lawyers and engineers will have to go through, but this will change. So I'll flick over it because it will change as we get to the final version. So you probably really want to know, because everyone can look on the internet to see what stage we're at in general, what my spies say is likely to happen over the next couple of months as we move towards the AI Act. And again, this will be a slide that we will destroy once we get to the end of 2022. The AI Act's definition of an AI system is likely to move closer to the OECD definition. The way it was written originally was very loose, and again, as I said, referred to see Annex 1. It's likely to move closer to the OECD's definition of an AI system, and we'll see how that works in reality. The second is that it may well be that there will be amendments to do with general purpose AI, particularly open source AI, because the open source community has been very worried about the extent to which they are being regulated for things that they are basically handing out to developers, and that might then be used for purposes that they didn't intend. So that might go back. Critically, I think for the AI Act, high risk AI is still being defined. And the list is still not finalized, and we will have to see. And as I say, the biggest public issue here is about live facial recognition and whether or not that's decided to be high risk or indeed unacceptable risk. And that will be a huge issue. For what it's worth, and I know this is being recorded, and so I'll probably regret this, for what it's worth, because the European People's Party is the largest party and effectively the leader of the coalition of the parties that get things done in the European Parliament, I suspect live facial recognition will be permitted within the AI Act, at least for the moment. But as I say, I'll probably be proven wrong by about February on this. And there's some other things. Oh, there's a couple of other things. One of the really interesting things is that metaverse applications are now being drafted into the AI Act. So sometimes when you actually hype up particular potential revolutionary environments, don't be surprised if this doesn't get tacked onto existing legislation. Oh yes, and the fines, I mentioned 6% for VLOPs. The fines as drafted are 3% for SMEs and are likely to be put down to perhaps 2% level. As I say, this is all going to happen many years in the future anyway, but it looks like they're going to decrease that percentage. Final point to note, which is that when this all will be proved to be a complete lie, is that the Czech presidency, which is there's a rotating chair of or presidency of the Council of Ministers, is pushing for the text to be put in provisional final form, in other words, to be then negotiated between the parties at the end of this year. But that may well not happen at the end of this year. That doesn't mean you have a piece of legislation, by the way. That just means you have a piece of draft legislation, which is the subject of negotiation between Parliament and Council of Ministers. So that's not the end of the process. That's the beginning of the real horse trading. Oh, and by the way, at that point, the process goes quite dark in terms of anyone outside of that negotiation doesn't really know what's happening for 6 months. Okay, Rob, I'm sure I'm speaking too much, so I shall try and skip forward. Oh, the OECD definition is there for people to see, and it's, I think, broadly acknowledged as being the most likely definition to be adopted. Okay, couple of points to make before I go on to explain the reality of how this happens. The first, and Toby actually put this rather well, not in his talk in Prato, but in a talk elsewhere, which is that it can be very, very difficult to work out what is AI and what is not, and what is a legitimate process and what is not. And I won't speak out his comment about Facebook, but you have it there. Second thing to say is that when we are dealing with the regulation of AI, these systems are, of course, already in the wild. They're already out there. And so we are, unfortunately, we are in a living laboratory, to go back to the Bruno Latour, Stephen Woolgar comment. We aren't able to revisit things. For those who know, this is, of course, from the Good Place. And you'll recall the philosopher in The Good Place is unable to make a decision in the trolley problem, resulting in just massacre after massacre as he attempts to actually decide what should happen. And we've all done our trolley problem discussions, I'm sure. Okay, so let me give you an example of why the DSA and DMA may play forward into the AI Act very well. I'm really claiming that what we're going to see is a lot more transparency and a lot more codes of conduct, not codes of conduct as in discussions of nice things we might like to see, but codes of conduct in terms of co-regulation, meaning the code of conduct is binding upon the parties. If they don't observe those codes of conduct, government can immediately step in and impose statutory regulation in place of what exists, which we have in lots and lots of sectors, particularly given my background, media, telecommunication sectors in particular. So we don't end up with a world of AI, which is where some people argue we currently stand, where Ponzi will not reveal his business secret. Hopefully we will move to a world which is more transparent than that. Okay, so very, very quickly, I think that the DSA and DMA are really significant milestones in actually dealing with what is internet co-regulation, but also will become partly AI co-regulation. I'll explain from one very, very specific example of why it's needed and why we're not necessarily in that situation first. Why it's needed is because we are entering a world in which the definition of AI will have to be adaptable as we develop legislation. There's no way that we can just set in stone one single definition of AI in 2022 or 2023 and expect that to be entirely relevant in 2032. I haven't met anybody who suggested that can actually be done. And so we will have to work between the co-regulators. Co-regulators, by the way, of course, doesn't just mean industry and government. That would just be corporatism. But also involves the other parties, other stakeholders representing civil society, representing user groups as well. And indeed academia for that matter, often actually acting as a proxy for user groups in terms of expertise. It does require some recognition that regulation, in terms of imposed from the top down, in 27 states of the European Union tends to fail, and I'll explain a little bit in a minute. We do have an ideal case study in failure to regulate using one sweeping law, which is the General Data Protection Regulation, which everybody is familiar with, I hope, or at least familiar with enough to understand that it was supposed to be a great flag-waving banner law. So I'm going to quickly talk to you about Portarlington in Ireland, the capital of GDPR non-enforcement. The formal date of compliance with GDPR was in fact 2018, the 25th of May 2018, although the law itself was passed in 2016. It was recognised it needed 2 years to actually implement it. And I'm going to argue we're still waiting in October 2022, which is now what, 4.5 years after the GDPR was supposed to be enforced. So the Portarlington effect, and we've talked about this a lot in the past in Europe, in various places. The term, by the way, was a term that was dreamt up, analysed and decided to be a pithy term by Michael Veal and myself. Some of you will know Michael at University College London. Michael and Johnny Ryan are currently engaged in very substantial litigation against the Irish Data Protection Commissioner. And it's about Portarlington is actually the site where the Irish Data Protection Commission was based from 2006. It's now shared with Dublin, so there is an office in Portarlington, an office in Dublin. Max Schrems, maybe the world's most famous law student, dealing at least with data protection issues. Max, of course, is now a lawyer who runs his own law firm dealing specifically with data protection litigation. He explained how Portarlington is. If I just tell you very, very quickly the process, it might make more sense to you. The Justice Minister in 2006 for the Irish government had his constituency in this place called Portarlington, which has 28 pubs and no cinema. It's the home of Pebble Dash. In Ireland, when they had a TV series trying to beautify individual towns in the country, Portarlington was the first stop to try to make it a slightly more glamorous place. And this is Portarlington. This is from Max's video from 2012. And the Data Protection Commissioner was in an office above the local cash and carry, the local convenience store in Portarlington. So I'm slightly, Max's video, and indeed everything that people have said, including people in Dublin, about Portarlington is unfortunately very prejudiced, and it's very unfortunate. But nevertheless, the fact is that when the regulator moved to Portarlington, all of the senior, and I say this almost without exception, all the senior lawyers in the Data Protection Commissioner quit, walked across the road to work for an American multinational in Dublin. So basically, it moved, the regulator moved to Portarlington. The senior regulators did not move with it, sadly. So it's a little bit of a case study in how these things happen. And of course, there's lots of academic literature looking at what happens when you have many, many different regulators who have the chance for a race to the bottom or a race to the top, what's called regulatory arbitrage. And in a world of not just 220 nation states with 220 sets of rules, but of course 50 US states. I think a few of us have become far too familiar with Delaware corporate law in the last month as a result of Elon Musk's attempts to not buy Twitter than we ever wanted to. We know that this world exists. All right. So self-regulation also, I think a lot of us know, has been a little bit of an issue in terms of the ethical standards around some parts of AI. I won't give you specific. Everyone has their own favorite example. And last time I shopped in Bunnings, I didn't realise I was becoming part of a natural experiment in how much Australian consumers were willing to accept their live facial recognition being deployed, for those of you who aren't familiar with the problem. So clearly we need to move beyond just self-regulation. Famous comment from Douglas North that regulatory action can be made to look at something like the mafia if you're not careful with your public choice theory, and lots of continued action. So let me just wrap up a little bit, but to say a couple of things. We know it's about enforcement, right? We know that you can pass a law at European level, you can pass a law anywhere else in the world, you can toughen up the Privacy Act of 1988 as much as you want. Unless you're concentrating on the enforcement issues, you're not going to achieve the outcomes that it seems clear that ministers here have now said at the federal level they want to see. So the enforcement issues, this is just an illustration of how you might deal with business models that aren't necessarily entirely ethical, are really important. So 27 NRIs in 27 countries, 27 chances. Here's the example I wanted to finish off with. In the European Union, in the Digital Services Act, the problem of disinformation is attempted to be dealt with to some extent. And what's been done is an attempt to move from industry self-regulation, so essentially what is a code of practice at European level, signed up to by the very large online platforms, the VLOPs. I said we'd come back to the VLOP term again. And they originally had a self-regulatory code of practice. That self-regulatory code of practice was considered to be not entirely appropriate by the European institutions. In reality, as Bontrida and Poulet have argued, this is Yves Poulet, who some of you might be familiar with, they said this is in reality self-regulation, not co-regulation. The Digital Services Act turns it into co-regulation by suggesting that without membership of this code of practice, companies would be opening themselves up to all of the liability that flows from allowing disinformation on their platform, which you remember I said was in the Digital Services Act 6% of global annual turnover. This is a pretty strong stick to be giving people in addition to self-regulation. So it's been described as descending towards co-regulation from the previous threat of direct state regulation, but ascending from the point of view of self-regulation. So think of co-regulation as being the golden middle, which far too many of us argue in theory without acknowledging that in practice this is hard. You're kind of converging on that idea. And so they refer to it as descending from above, from the Digital Services Act. It certainly is in place. And without going into huge detail, I just think this is joyous, and Elon Musk, I'm sure, will enjoy this when he thinks about buying Twitter. There is an assembly, in European terminology, which always borrows a lot from the workings of the Catholic Church, they assembled together, and the Assembly of Disinformation Parties agreed they would have a vademecum. I had no idea what a vademecum was, so I went away and did what I tell my students not to do, which is check Wikipedia. And it turns out vademecum is simply Latin for handbook. Who would have known? And they have this handbook on how you strengthen the process of co-regulation effectively of this code on disinformation. And it is now written in, and by the way, people who scramble away and go, well, this thing isn't even written in law, so what was Chris talking about? It's in recital 68 of the Digital Services Act is where you find reference to this. It's extremely obscure, but I promise you this has real teeth, and the parties are very aware of this thing in existence. By the way, if it turns out that they've changed the numbering, and there has been a threat that the numbering has been changed, I will let you know what the new numbering is of that particular recital. Okay, so my conclusion is simple. I think we're going to move towards more co-regulation, not just for AI, but actually across digital platform governance in general. We know self-regulation has its limits due to lack of enforcement. We know hard law has its limits because of the pacing problem, that simply you can't keep up with the changes in legislation, no matter how flexibly you try to write it. And so we very often come up with this horrible term used, online harms, which in London means pretty much anything, it seems, including things which are neither criminal nor civil legal breaches, but seem to be some kind of a morality breach even. All of these issues, it appears, are being dealt with more and more through co-regulation and through codes of conduct of different types, although with some direct enforcement. And Ian Brown and myself, Ian, who I wrote the Regulating Code book with, we wrote it in Melbourne 10.5 years ago, which dates all of us probably. We've looked at this in the case of App Store regulation, amongst other things as well. That's what's happening. I'm very welcome to suggestions that that's not necessarily what's going to happen here. And I think maybe I will just wrap up at that point, except by just saying the one final thing which makes European lawyers so happy is that we are going to legislate at haste in 2022, 2023 with an AI Act. In the same way as we did at the beginning of public acknowledgement of the internet in Europe with the e-commerce directive, which was really written in '98 but became law in March of 2000. And I think we're moving towards our next iteration. So the next iteration of the e-commerce directive has turned out to be this Digital Services Act of, please let it still be 2022 because it's not been published. And I think 22 years on from the AI Act is the next AI Act of 2045. By which point I'll be retired, but I see my career in mapped out in front of me. So there we are. I hope that provoked people into some thoughts. Thank you very much.